All right, welcome back to the House Environment Committee. We're going to shift gears and start talking about S325 with, I think it would be good to do a reprise with our legislative council on the sections of 325 and have Q&A based on testimony we've taken and also thoughts on sections. But additional to that, I think all of us actually have now hard copies of Act 181. And if there's sections of that we want to look at with legislative council, we could do that after this. Unless someone has a reason to do that before this on a section they want to hear. Yeah. Okay.
Okay, Ellen Tchaikovsky, Office of Legislative Counsel. S325 is still as passed by the Senate, so there haven't been amendments yet. Did you want to start at where did you want to start at the beginning? Okay. So this is an act relating to regional planning and Act 250 tier jurisdiction. The first section is an intent section. It says the General Assembly finds that 2024 Acts and Resolve number 181 represented a substantial restructuring of Vermont's land use review framework. This act is intended to provide technical clarification, transitional certainty, and implementation alignment consistent with the intent of Act 181 and without altering its underlying policy goals. So you may want to consider as you make changes if that section also needs to be adjusted.
Yeah, and so from here on out, we could just do high level what the section does and then see if there's questions about it.
Okay. So section 2 starts with the amendments to Act 250. The first one is in 10 VSA 6001-3, which is the definition of development under Act 250, which are the jurisdictional triggers. And so the first change that's being proposed is at the top of page 2, which is pushing back the implementation date for the road construction jurisdiction, and also called the road rule. Currently in statute, it is going to take effect this July 1, 2026. And then also within the statute itself, it says it applies to roads constructed after July 1, 2026. And the Senate has proposed to push that back to January 1, 2030. Next starts some of the amendments related to the interim housing exemptions. So on page 2, this is the interim housing exemption for priority housing projects. So it removes the cap on how many priority housing projects can be built under an exemption from Act 250. And so currently in statute, it says that this exemption goes until January 1, 2027, pushing that back to January 1, 2028. And so to remind you, priority housing projects are affordable. They have to have an affordable element. So they have to be either mixed use or mixed income housing. And they have so there's a requirement that at least 20 of the units are affordable as defined in the statute for at least 15 years. And then they also have to be located currently in statute in one of the designated areas. And so in addition to this amendment for the temporary exemption, there's also a change to the definition of priority housing project in section 3.
But this language at the top of page 3.
Yes.
We talk about that.
Sure. So this is one of the interim housing exemptions. There are 3 or 4 others, depending on how you count, in section 6081. And those interim housing exemptions contain this language that is being proposed on the top of page 3. So the priority housing project exemption did not have this language about whether or not the exempt units could be built in river corridors. The other housing exemptions do currently.
If we have the others, why do we need a separate one for priority housing projects? Exemption. Wouldn't they be covered under the broad ones?
Yes. So this one was enacted earlier in time than the other ones. This was, I believe, part of the Home Act, and there was a couple. I believe there were 2 that were enacted under the Home Act, and then under Act 181 the next year. one of those was repealed and replaced by one of the interim housing exemptions. This one was just extended. So yes, this exemption is for affordable housing units. There's no cap if it's located in a downtown neighborhood development area or growth center and within 1/2 mile around. So that is a change to how it worked previously. This 1/2 mile around the center is different than how it has worked previously. And then also there's no cap on the number of units that can be
It used
built.
to have a cap that floated with the size of the town.
Yes.
And so the other housing exemptions are not, and well, first of all, the priority housing project, you mentioned it, it only has to be 20% affordable
Yes.
and only for 15 years.
Yes.
Even our priority housing project that is supposed to be affordable focus and allows for all kinds of other market rate houses.
Yes, it's a minimum. So some projects do contain more affordable units, but there's only a minimum threshold.
And then after 15 years, even if public dollars go into these projects, they can be sold for market rate.
Yes.
Yeah, part of our problem.
Did you want to talk about the river corridor language at the top of page 3? Or
Yes.
so this language, so it says this exemption shall not apply to areas within mapped river corridors and floodplains, except those areas containing pre-existing development in areas suitable for infill development as defined in 29-201 of the Vermont Flood Hazard Area and River Corridor Rule. So I'm not sure initially why this was not included in this section. I think there are policy reasons to include it or not include it. It is in the other interim exemptions, and it appears in a few other places, this concept of building in the river corridor and floodplain is not allowed unless it has been identified as suitable for infill development. In past sessions, this committee has discussed that and what the rules define or allow for as suitable for infill development.
Testimony on this yesterday from the Land Use Review Board, and they made a recommendation on this related to environmental justice. Am I remembering? Give that note, Ellen.
I didn't write anything down about them talking about this, so I don't know if they did. Yes,
Yeah, they did.
yes,
Yeah.
they did. They did say that it would be an environmental justice concern.
To allow the infill. Is that what I'm
Yes.
looking at their,
Yeah.
I'm looking at their testimony for it and I can't find.
I think it was just a comment outside of the. Oh, yeah. No, but you're right. That's what they said.
As it related to this specific question or area.
Yeah, this
Okay.
specific.
So I think we should think about that. Some.
And I'm here
Yeah.
if you want to use me.
I'm sorry, I couldn't see you.
Sorry.
And over there, with our great witness.
Yeah, Pete Gill, Land Use Review Board, Executive Director. The board does support inclusion of that language into the as written in 325. And certainly to be similar to the other language within those exemption areas and make sure that the environmental justice issue that's raised there with having priority housing projects potentially in areas that could have flooding risks, making sure that that is addressed.
I found my note where they did say that. They actually didn't say it related to the top of page
Yeah,
3.
yeah.
They said it related to the floor amendment that's on page 7.
That particular comment came in a different section, but just for your information, we do support, the board does support that inclusion of that flood language in PHPs.
Okay.
So
Representative Austin.
Yeah, when I was reading the bill, that just seemed very strange to me that we would allow infill building in a floodplain.
Yep.
Again, that doesn't make sense to me.
Well, we can talk about it again. Like I think I said, this committee usually comes to that conclusion
Okay.
and others don't. Representative Logan.
Thank you. So to clarify, the language at the top of page 3, this exemption, the priority housing project exemption, shall not apply to areas within mapped river corridors and floodplains, except those areas containing pre-existing development in areas suitable for infill development as defined as 29.20.01. So this is our rule that we're developing about where it's acceptable to provide infill housing.
I think this already exists.
This already exists.
Yes.
But aren't we in the process of redeveloping that rule?
I think so. I'm not sure where in the process it is.
The LRP does support that.
Yes, it's consistent with the, relatively consistent with the language throughout the statute. So that the general concept of making sure that that exemption does not apply to those areas, but for that determination by the consistent with the agency's infill requirements. Correct.
Yeah, that segues nicely into my comment, which is about what we mean when we say suitable. Because I think we do have some guardrails around that potentially in rule or in terms of how the agency would actually allow such development. And so it takes some of this into account perhaps. And then the other thought I just had was I remember when we were talking about this, I think when we were working on what became Act 121, the Flood Safety Act, that we saw cases where, in particular, the river corridor infill development was thought to be potentially acceptable because the rivers are really locked in place in some of our downtowns and other highly developed areas. And so the idea that the river would actually be moving through the mapped river corridor in those places was not going to happen. And that those areas are also sometimes high enough that they're actually out of the floodplain. And so there's a lot of nuance, I think, in terms of what we're trying to say is allowable to happen here.
Yes, and I would say, so it's a little bit of a calculated risk, still a risk of erosion hazard, but there's already so much development in these areas that I guess the thinking is that, I mean, it's hard for me to say because I don't agree with it, but that we're gonna continue to maintain them and hard armor them. And there's other investments there. And if there is a catastrophic flood, then probably we'd have to have a new conversation about it, but they're already there and generally protected through investments, hard armoring and such. Representative Chapin.
So just to clarify, without this language, priority housing projects right now can get exemptions from Act 250, including in areas that are mapped as river corridors and floodplains.
Right.
This
This
narrows
it.
but also still allows it in these
Yeah.
predetermined areas.
Yeah.
So it does narrow it.
Yeah, it does
Yes,
narrow
yeah.
it. And it's temporary because priority housing projects go away as soon as Tier 1B and Tier 1A go into effect.
Yeah, if they go into effect, yes. Okay, it does narrow it, yes. It's just trying to make it consistent with the other housing sections. I think that's enough on this section.
So the next section on page 3 is section 3, and it is about the definition of priority housing project. Like Representative Logan just said, there is a question about what happens to the definition and concept of priority housing project as this new program moves forward, because in Act 181, you changed the existing state designated area program to the community investment program. And so currently the definition of priority housing project is tied to designated areas. And so if the designated areas are going away as part of being renamed as part of the new program, what and there will be exempt areas for the construction of housing. What should this definition be? So the Senate is proposing keeping at least the first part of the definition and then adding to it. So a priority housing project means a discrete project located in a single tract or multiple contiguous tracts that consist exclusively of mixed income housing or mixed use or any combination of thereof, and is located entirely within a downtown development district, designated neighborhood, new town center, designated growth center, or designated neighborhood development area under Chapter 76A. And Chapter 76A is set to sunset in 2034. So they've added or within an area mapped and approved by the board as eligible for Tier 1B area status and is not currently approved for Tier 1B area status under 6033 of this chapter. So this is a new concept of areas that are mapped as eligible but are not as approved as Tier 1B.
Yeah, and we had a little confusion with this yesterday, and my understanding that the RPCs are mapping the areas that they consider eligible, but that approval would come from the LURB, right? So that seemed like a sticking point yesterday with the LURB, and I'm not sure why. I don't know if everyone seeing some nods, and I'd like our legislative council to opine on that.
Yes, I think this language is vague. Because I think it is attempting to potentially cover a couple of different situations. And I'm not entirely sure how it will play out practically, but there are a couple different requirements for what can be included in a Tier 1B area. One of which is the municipality opting in specifically. They have to identify that they want that area to be approved as Tier 1B. So this could be addressing, I think the Senate was considering addressing the situation where a town had not opted in. I think they also were considering areas that had not been approved as part of the new update of the regional plan. I don't know what this would mean 5 years from now. I'm not sure how many there will be eligible but not approved.
Representative Logan.
Yeah, I just want to follow up on what Ellen said here. I think it could potentially apply in the case where, you know, the Tier 1B area does want that status as after being mapped by the RPC. That would mean that they're under, you know, full Act 250 regulation. So they have no exemptions, and then this would allow for priority housing projects to continue to go on in those areas. I think it's also like recognizing that there are some communities that are not opting in, even though they have areas mapped that are Tier 1B eligible, because they don't want to build multifamily housing in their communities. And so this would still allow for priority housing projects in those communities as exempt from Act 250. And so then it would essentially clear the way for approval of priority housing projects in those communities with minimal community objection.
I guess I don't agree with the exempt terminology, right? So in Tier 1A and Bs, towns are required to do rigorous development review. So they're not exempt.
Oh,
from
no,
permit
I
review.
understand. No,
I just want
yeah.
us to, like, that has been used inaccurately, and I think we're getting better about it, but so it's not an exemption. And I would say, I hear your concern is that there are towns using this to keep out affordable housing projects. But I also think there are towns that want the Act 250 review, so it doesn't keep
Sure,
them out,
absolutely.
and or they don't have the resources to do the local review. So it's not always nefarious on the part of the town.
Absolutely. But in some cases, it is explicitly why the town, and I won't name towns, but it is explicitly why the town is not opting for the tier 1B area status. And this would still allow there to be an incentive to build affordable housing projects in those communities that would then, not be under Act 250 review, which would trigger certain potential criteria where the community could try to, prevent the development.
Yeah, so I get it. And at this point, I think what we need to do is try to understand how all of these amendments interact, which will be tricky.
Yeah.
And so this one, I get it. These are towns that have zoning and subdivision bylaws and, because I don't think you could be a 1B without that,
Yeah, I can't.
unless we let some of these amendments go through. So that's what we need to pay attention to. Okay. Representative Moore.
Thanks, Madam Chair. I just want to ask a question to make sure that this wording is accomplishing what we're trying to get it to accomplish. And maybe it's just me not understanding the wording, but that key phrase, by the board as eligible, appears in the first part of the sentence within an area mapped and by the board as eligible for tier 1B, but then it's not currently approved, still using that same word approved, but then doesn't have that little phrase by the board as eligible. It just says approved for tier 1B. What does that mean? What I'm trying to understand what that means.
I think the only information I can give you is what I've already said, which is the Senate requested this language, and I think they were attempting to address multiple different situations, and so I don't find this language to be clear.
Yeah, that's true. Is there a way we could make it clearer and be accomplishing what it is we're talking about, trying to accomplish?
The Senate's a big term. Where you know where it came from? We can check back with them.
It happened in Senate Natural Resources.
We'll circle back. Try and figure out their intent. Okay.
So,
Let's,
So section 4 then is the amendments related to the other interim housing exemptions. So there's just a grammar change at the bottom of page 3. But then on page 4, the first change is in subdivision BB, and this subdivision BB and CC predate Act 181. They're from the Home Act. And so I believe, and so they are on slightly different topics than the rest of them, which is BB is for an exemption from Act 250 until currently July 1, 2028 for no permit or permit amendment for accessory dwelling units constructed within one single family unit. And they're extending that to January 1, 2030. And then also CC is also extending from July 1, 2028 to January 1, 2030. No permit or permit amendment is required for converting a structure from a commercial purpose to 29 units or fewer of housing.
so under the BB on the previous page, I think I remember processing this mentally when it happened. It was, I think, envisioned for new construction that the ADU wouldn't actually count as an additional unit when calculating how units were, but also, but related to Act 250 review, which is suspended. So that's your point about maybe we don't need this either anymore, because these are areas that are temporarily exempt from Act 250.
Potentially. It does say the last sentence on the bottom of page 4 does address that these units shall not count towards other unit totals. So there was a lot of discussion prior to 181 about the Act 250 jurisdictional trigger of 10 or more units of housing. And if that should be changed in any way. That was before the other interim exemptions were created. And so I think this was to address,
Oh, so this is actually statewide anyway.
yes,
Okay.
it isn't specific to any of the designated areas.
And I know that there's been testimony that this has unintended. Anyway, the construction of ADUs has had unintended consequences in some towns.
And then as I mentioned on the top of page 5, CC, so this is a change of the date on this commercial conversion to housing. It's changing the date. It's also adding the existing exemption is for no permit amendment is needed, which implies that it's a project that already had a permit. And this is now changing it so that no permit or permit amendment would be needed if it's a commercial building being converted to 29 units or fewer of housing.
A question? Representative
So-
Morgan?
I would assume that this arose because of specific examples.
The amendment or the original?
Amendment arose because of specific examples where
Subdivision.
developers with previous permits found that they would be required to get an amendment to projects that people don't even need a permit for right now. Is that the idea behind this one?
I don't think so.
No?
I'm not aware of that. I thought when I thought that this was for only projects that already had a permit and were converting to housing and therefore didn't need a permit amendment. But this is contemplating that even if it's a structure that doesn't already have a permit, it also doesn't need a permit if it's being converted to housing.
But it also
Oh,
doesn't
yes.
need it for subdivision. So this, I see, yeah.
Gotcha.
And mixed use developments is being added.
Oh, no, I'm still at the top.
Oh, sorry. Oh, you're this subdivision. Got it.
Sorry. So
Well,
it's very possible that someone had examples when they asked me to draft that. I'm not always aware of them.
But this seems consistent with other exemptions that we're allowing.
Well, it was, I think, consistent when at one point there was a 30-unit exemption
Yeah.
and there isn't a 30-unit exemption anymore. But again, this is one of the temporary ones. It is a little unusual.
I'm still just trying to get my head around this. This is also from the Home Act.
Yes.
This was pre-Act 181. Trying to imagine commercial buildings that can be converted to 29.
the idea was
or fewer.
motels.
I thought it was mills.
I remember
Okay.
motels. I don't remember mills, but it would be anything like that. Sure, it could be. Oh, yeah.
I'm just trying to imagine a commercial project like this going from commercial to housing that didn't already have an Act 250 permit.
I think that's why they're saying you don't need an amendment to it.
Well, that's what it originally said.
Originally, this was just for amendments to Act 250 permits. And now it's extending it to make an exemption for it. Like if you don't have an Act 2 permit,
Yeah.
Act 250 permit already, you wouldn't need an Act 250 permit at all. It feels like a pretty big extension. So I guess
Yeah.
I need some more testimony on this.
Yes.
Yeah. Well, we gotta figure that out because. Yeah.
Okay, still on page 5, DD are the interim housing exemptions from Act 181. The first one is for no Act 250 permit or permit amendment in new town center, growth center, or designated neighborhood development area with served by sewer or water services or soils adequate for wastewater disposal. And so currently, this is for 75 units of housing or fewer. And the current date is until January 1, 2027. It's being extended to January 1, 2030. And it's also adding for the subdivision of and mixed-use development. So it's 75 units, but it also could be the subdivision for 75 units or mixed-use development with 75 units.
You have a chart of these exemptions, or I guess maybe I'm asking for a chart of them. We need I think we talked yesterday about the bill summary, and
Mhm.
maybe it's up under your name now.
Yep.
Okay, is it?
Yes.
Okay, so that might help us track these better.
Okay.
And that includes the Home Act as well as Act 181. Well,
I didn't hear the first part of the question.
and does that include the Home Act as well as Act 181?
Only to the extent it was amended by Act 181.
There might be one for the Home Act also. Okay, because these are all.
Oh, yes.
around
there's-
each other.
Yeah.
Not-
Okay, so this same change that's being made for the 75 unit exemption is also being made down in subdivision 2. It's changing the date from July 1, 2027 to January 1, 2030. And it's no permit or permit amendment required for the subdivision 4 or the construction of houses and mixed use development with 50 units or fewer.
John,
Sorry.
you a little on the spot, but if you can, as we're going through this, help us, because I think you tracked this bill pretty closely in the Senate. Is that right? You tracked S 325 pretty closely in the
Yeah.
Senate. Help us identify witnesses to have in on the language, because we are kind of floating here, and
Yes, absolutely. A lot of-
we can reach out to them as well, but if you have thoughts, that would be really
Yeah,
helpful. Like,
especially Katie's coming in tomorrow.
Yeah.
A lot of it really is in Katie's area, but
I'm guessing Katie didn't make requests for these changes, so we're just
No.
even very fundamentally trying to understand what the intent is before we understand.
Yeah, we can do that.
Thanks.
And so this subdivision 2 is 50 units of housing, and then extending it to the subdivision 4 and mixed use development with 50 units of housing. And then on the top of page 6, this is the rest of what this language does. And so currently it's 50 units of housing exempt in either a designated village center and 1/4 mile around it with permanent zoning and subdivision bylaws and served by public sewer, water, or soils that are adequate. Or 50 units of housing within areas that are within a census designated urbanized area with over 50,000 residents and within 1/4 mile of a transit route. That is a very specific area and part of Chittenden County. There is only one area that fits that description. I believe it's along Route 7.
Not anymore. Do they still have transit?
Operating.
And then at the top of page 6, we did discuss this last time, but one of the floor amendments is what's the language that's being changed on line 1 into 2. So currently this exemption requires it's 50 units of housing on 10 acres or less and located entirely within those areas. And so now it has removed the reference to it being on 10 acres. So it could be any size project. And then it also strikes entirely within. So I guess it only needs to partially be within one of those areas.
Yes, and just the opposite of the direction we're trying to head here. I need to ask council to remove that.
What are you talking about? You talking about page 7?
Page 6, line 2, 10 acres or less.
Is this a floor?
Yes.
Hmm.
The was a floor amendment.
Yes.
Know what the specifics behind the request for that amendment was before we try to pull it. What you brought up earlier, I think is a good idea, trying to get people to come and talk to us about why this stuff is specifically got put in there.
For this one, you can let us know who that is if you want. For me, this one is allowing 50 units on as much land as it doesn't have any bound on it. So the idea is to have compact villages. Representative.
Right, so just to be clear, this would allow, for example, an extremely large development covers a lot of acreage that may only be partially located within,
Right, within a quarter
And-
mile.
within a quarter of a mile of a designated village center. Or in that section of South Burlington, just shelter. That's on Route 6, the Green Mountain Transit Line. So, yeah. That's a gigantic expansion.
Yeah.
I mean, if others in the committee are interested in hearing testimony on that, and we can find a good person to advocate for that, but fine, but I also agree that I'd be fine with it being taken out.
I understand that concern. I just want to make sure we're reading it right, because the 50 or fewer units located, it still says located within, and then it's got to be areas of the village center, 1/4 mile from the boundary. Like I'm just trying to think of scenarios that are happening. Maybe there is like a 50-acre parcel that some of which is inside this village center, and you're saying, my understanding is, and maybe I'm wrong, but my understanding was that the 50 units could be built within the village center of that 50 acres, but the rest of the 50 acres isn't allowed to be built on. It's just the part that's within the village center, 1/4 mile of its boundary.
Well, they struck entirely.
Yeah.
Well, I
guess
know,
that's the
but
question, like,
that
what's
just
the
means,
significance of
yeah,
entirely?
the 50 acres is not entirely the 50 units.
No, no,
That's the way I would.
50 or fewer units located within.
Yeah, that,
It doesn't say the parcel. It says 50 units located within.
I think Rob's right.
I think, yeah.
I think the
just
units
to-
you got a little corner of a big parcel that happens to stick inside.
Subdividing off,
You-
yeah.
Yeah, you
This is
want,
really
you
a
want.
question for the town.
I just want to understand the technicality of it right
Yeah.
now.
Would the 50 units have to still be within subdivision 1 and 2 below, or not?
I don't know.
What's the effect of striking entirely?
Well, especially because also it strikes that the tract of land has to be located within.
Yeah.
I'm not sure.
It's
I-
definitely causing
If-
confusion.
We could leave the constructed, maintained or tracts of land, 10 acres or less, we could leave that part struck. But unstrike the entirety, so that the 50 or fewer units, all of those 50 units are within. But it may be on part of a piece of land that's stuck way outside. It's just that all 50 units have to be on that little corner that's within the village side.
I guess the question is, what's the problem we're trying to solve?
Just in case somebody owns a big piece of land, part of which sticks into the village center. And they want to,
There's subdivision. Yeah, I'm imagining it's possible. That's the problem. It would be nice to actually hear what I wonder
Yeah.
the problem is.
yeah, why couldn't they just
Specific
subdivide that little piece and say?
Because that's what it is.
Yeah.
Yeah, representing
I
Sac.
think that gets to whether we want to strike the entirely or not, but we still are left with the 10 acres or less. And getting back to Chair Sheldon's point, it's conceivable that there are some very large lots within some of these designated areas. And we would be saying that you could build 50 or fewer, like you could have a development of much fewer than 50, like maybe 10. And if you had a 100-acre lot, you would be allowed to have 10-acre lots.
But I was.
That seems to be
The
a
opposite.
problem. That seems to be a problem. That's a problem for me. Seems to go against what we're trying to do.
Yeah, no, I understand that. It's just, there needs to be some density constraint. That's what we're really trying to get at.
That's what it had.
That's what-
Even if it's on a piece of land that's much bigger.
I think as written, it had a density constraint.
Yeah,
That's been deleted, and I was thinking that we could actually make an edit that the majority of us agreed to. And
Yeah.
move on, because we do, the session will end, and I think it's an agreement, we want to do something with S325 during this biennium
Mhm.
and not belabor every decision along the way. And with that, we have a another amendment to consider before lunch. So when the folks from judiciary get here, we can wait.
Oh, sure.
Do you see my gold rating?
No, I don't.
So they're not,
It looks like they just wrapped up their testimony.
yeah. Here's, boom. I guess it's a good time for us to pause on 325. Representative
What
Austin.
is a tract of land? How much, what is a tract?
It's a parcel.
But does it have dimensions?
No.
No. So you could have one tract or two tracts?
Mhm.
Why wouldn't you just have one tract with no dimensions, or does that make sense?
I think it's just more tied to, Act 250 jurisdiction generally is tied to the whole lot. And so it is described as either a tract or tracts of land. It may be subdivided.
You have one other final thing?
Yeah,
on this?
maybe just to wrap up this conversation on this piece, it took me a little while to get there, but I don't think the problem is what you and I are imagining, where you have like 100 acres and 10 are inside this, one or two areas that are eligible, and the issue is about subdividing or not subdividing. I think that issue, or doing the housing outside of that area, I think the issue, I'm looking back at my notes from the VNRC's and the LURB's comments on this when I asked about it. And it's that it's really about density, and that this was a density constraint to make sure those 50 would be on 10 acres or less, regardless of how many parcels are subdivided or not subdivided it was. And so this is really removing a density constraint so that you did have 100 acres that are within one of these eligible areas. You could have very undense housing. So I guess personally, I don't really support that change.
It seems to support sprawl.
And I don't feel like we have a lot of time to like dive into things that didn't get even discussed in this.
Floor amendments, though, yeah. All right. Thank you, Ellen. We'll
Thank you,
have you
Ellen.
back soon, I'm sure.
If it's density, it's fine. You probably just specifically say density. Say one unit at a minimum per acre or something. It's 50 or fewer, so it could be one. It could be one on 10 acres.
Well, that would trigger out.
It could be less.
We're happy to come in. Okay, great. Thanks. Do you want us to email you, or are you watching our
To be
agenda?
under Act 250.
Yeah, if you can email when it works.
So we're saying
Great, we'll try
like
to-
between 10 and
Thank you.
10 and 49.
I thought they were ready to come in. Come on in. So no, I don't. See you in the hot seat again. Yes. Join us. Where's the language locatable?
You look, I emailed.
Yes.
In the home. Is it?
Sorry, it's emailed from the clerk or emailed from you?
It was, I think it was sent, by Nigel to everyone, or it's in the calendar, because I think I made the cut off.
I have to-
But. One minute. We go take a look. It's the one that references tort claim. The Tort Claim Act.
It looks like it's on the judiciary. I will post it onto ours.
On the calendar too.
The action calendar in the house.
Okay. Tell me about your new amendment.
Yes, so first, my name is Michael Booton, Berry City State Rep. I do want to say thank you to this committee for pointing out something that was in that amendment that was not supposed to be in that amendment. So I do appreciate that. After reviewing it with Ledge Council, what we did was we wrote language in there that would literally just point to the Vermont Tort Claim Act I can't remember when it was, but it just points to the Vermont Tort Claim Act regarding salt issues and for municipalities. And that is all it does. It's the same pitch that I made yesterday, except for I took care of the problems that you brought up in committee. So it does parody the state of Vermont's situation, which is what I wanted to do to begin with.
And, Representative Hoyt, I'm just kind of curious, do you know where Michael O'Grady is? I know.
Did stick his head in.
You know, I think that
F2.
when I looked at the agenda, it didn't look like either one of us were scheduled.
We were waiting for you to get through judiciary.
Oh, sorry.
Oh, here he is. Great.
I'm assuming VLCT is also on the witness list as well.
We'll see how this goes. Representative Hoyt.
So, thanks. So would this change mean that if a municipality has insurance, the recovery someone would get exceed the cap?
Yep, it does exactly what the state of Vermont has, because it think of it like this. I have bootenforberry.com. And part of that, if you go to that website, you will be redirected to my Wix page, which has my actual Booten for Berry information on it. It's just a redirect to the Vermont statute regarding the section for municipal salt applicators. And that's it. Doesn't have any impact on your bill.
Representative Hoyt.
I guess one of my concerns with this is, and we heard some of them yesterday, just about sort of the scope of this and whether or not this really needs like a separate bill with full vetting. But this seems like there are a lot of things municipalities do and a lot of things that they can do negligently to injure someone. But this would just limit this hard cap essentially to salt applicators. So it's kind of just a piecemeal thing, right? There's this hard cap for this, but not necessarily for anything else a municipality does. So it seems, I mean, I guess that's because, you know, there may be some germaneness issues or procedural issues, but I think sort of troubled by like the fact that just one particular segment of their operations being singled out and getting the benefit of this. Do you have any?
Sure. So what I'll tell you is that the LCT has been fighting hard to get the same parity with the state. Correct.
Not just the salt.
Correct. Because if they had parity with the state of Vermont, it would apply to the salt bill. The problem is that bills have been submitted over and over and over again, and it never gets talked about. And this is an opportunity for us to talk about it, one, and to provide that parity in this one section because of the germaneness issue. You know, I've been on record multiple times stating that, you know, I fully support a full parity, but that's not where we are right now. And I know that, you know, the question is, you know, maybe this isn't the right way to do it. And the question or comment that I made in judiciary is, if not now, when? And because when never comes. And that's the reason why I put forth the amendment, because we need to start somewhere. And this is the place to do it. You know, the VLCT wants to support this bill, but this is what's needed to fully be on board for it. The way that I understand, you know what? I shouldn't speak for VLCT. I would highly recommend that they speak for themselves.
Yeah.
So I take back my comment, please.
Representative Hoyt.
Just one thing on that. So talk of this as like a start, but you also mentioned that VLCT's been asking for this for years. So if this did get passed, I mean, it's probably less of a start than just an outlier. Like it's just going to be that one particular municipal law.
Yeah, it is an outlier. It's a start of the conversation. I think we've had more conversation about this, about my amendment, than we have in the last 15 years since the caps were dropped back in 2011. I will say that there's some benefit to, I'm not sure who's from Burlington, but I'm sure that folks in Burlington would certainly appreciate this amendment, and I would defer to VLCT on any specifics regarding that.
Representative Austin, do you have a question for the, from
I think
Representative?
so. Just to clarify, our bill is voluntary,
Hmm?
right? So would this bill cover voluntary and non-voluntary workers? I mean, just for normal workers,
Ours is a voluntary program.
right?
Right.
People are making money. They're commercial operators and
Right.
municipal.
Right.
And
Would there be
I-
any difference between someone who volunteered or someone who?
We're not talking about
I think I know the question.
volunteer. You mean volunteering for the BMP program?
Yes.
Yeah,
That's a question for O'Grady.
I think I understand the question, though. What you're asking is if they go into the program or if they don't go into the program. And it would cover both, correct? It would be for those that don't go into the program and those that do. The people that go into the program,
I think so. Can we hear from Ledge Council on that question, please? Because it says for people who don't qualify. Would it cover both people who were in the program and out of the program?
I think that that's the intent, that if the,
You don't have to wait.
if they are in the program, they don't qualify, they get the cap. If they aren't in the program, they don't qualify for the affirmative defense either, and they get the cap.
It would cover people who participate and don't. Okay, thank you.
So, just to clarify, if they are in the programs, but they don't qualify for the affirmative defense to liability, that means that there's pretty serious negligence involved, right?
Well, it could be gross negligence or recklessness, but it also could be failure to follow the BMPs or failure to maintain the necessary records of application.
and I'll just say, regarding records, sometimes it's difficult to maintain records and sometimes you make a mistake. And could a lawyer drive a freight train through that? I would probably say yes.
Representative Sacco.
I guess I'm still not clear as to why the language around having or not having the affirmative defense is pertinent here. Like, what if we just took out all reference to affirmative defense, but it still do what you want it to do? Is that language doing something important here?
If you don't qualify for the affirmative defense, because the affirmative defense is 100% liability protection.
Right,
You're not liable if you qualify.
right. So, sorry, Michael.
If you don't qualify for that, you still have this liability protection under Representative Boone's proposal. You would have the cap at 500 and 2 million, but it's also, if you're going to follow the State Tort Claims Act, it's a cap up to the amount that the municipality has insured itself.
I think I understand that. I think the part that I'm not as clear on is if we took the reference to affirmative defense out of this amendment, what would actually change in its effect? Wouldn't those people still get the liability, the protection of the limits that you're looking for?
They would, but
What would we be including that we don't want to include?
I think you would be including the reference to the fact that they could have had 100% liability protection. So if they qualify for the affirmative defense, they don't need the cap that's being proposed. They don't need that protection. They are not liable. If they don't, that's when they need the protection.
Right, they don't need it, so we would never even, maybe whether it's in there or out or not in there, doesn't matter, but if we are going, but if we're gonna change the statute, it seems like this extra language wouldn't actually do anything.
I think, okay, yes.
So
Which extra language?
about the affirmative defense, that if they don't qualify for the affirmative defense.
Well, if you took that out, then you would have the liability cap apply to everyone
Wouldn't get 100%.
in the affirmative.
If you do qualify, you actually get. What, I can't remember the word, but you don't have any negligence. We need to actually invite Representative Lamond right now.
Thank you.
Thank you, Martin Lalonde, representative from South Burlington, chair of the Judiciary Committee. So the bottom line is this isn't ready for prime time is the primary reason that we voted unfavorable 7-3-1. And just to back up a little bit, there is a bill on the wall. In fact, I'm a sponsor of it for the broader municipal caps and such. And as often happens, as we all know, when we have a wall full of bills, sometimes we can't get to the bill. So we were unable to get to that bill this year. But that's the first time I've heard of that. Is the first time it came to my attention was this biennium. So maybe they've been pushing for it since 2011, but I've been around since 2015, and this was the first I've heard about the desire for this, at least in the Judiciary Committee. But putting that aside, the main thing is that we really we'll simplify this in my mind, because it actually is very complicated underneath the simplification, is that I'm worried about the individual. We're worried about the individual. Actually, under the State Tort Claims Act, which I think that's one of the things we want to actually look at to see how that's working before we have the municipality go underneath the Tort Claims Act, to essentially be treated the same. The concern is that if an individual, because of the negligence of a state employee or a municipal employee, gets a catastrophic injury, that we should, the state or the municipality, often through their insurers, should take care of that person's medical bills and take care of that person. And the example is the individual, because of negligence, the woman who was a quadriplegic because of the negligence of a municipality. We need to take care of those individuals. They don't happen very often. It's few and far between. But when they do, we need to make sure that we have that protection. Will insurance cover this? That's a big, it's really kind of a big question. It's of whether having it follow the state law, where there's this provision says if there's insurance, you're going to use the insurance, you're not going to have the cap, you go over the cap. Well, we really want to explore how that actually works, because then it seems to be like a problem. There's no problem looking for a solution, because if insurance is going to cover this all, why do you need the cap? I mean, it seems there somewhere that the cap is going to keep these individuals who are catastrophically injured from being taken care of. It may be fine, but we really need to dig into this more deeply. This needs a lot more vetting to make sure that we are not doing a disservice to Vermonters through no fault of their own, but through the fault of the state or municipality, are seriously injured. So that's why we voted this to be unfavorable. And I'm happy to answer questions.
Members have questions for the representative. Can you stay with us though till?
I can stay until noon. I just have a new meeting on forensic facility bill.
Samantha Sheehan, do you want to comment just on the
Sure.
problem you're trying to solve?
Yeah, I would love to. Thank you. To break. Hello, for the record, my name is Samantha Sheehan. I'm the Municipal Policy and Advocacy Specialist for the Vermont League of Cities and Towns. And I'm happy to answer any questions that you have. I guess I'd first like to state clearly that VLCT supports the current amendment being proposed by Representative Booten that would create this sort of liability net underneath the affirmative defense liability protection in the bill that you all have worked on, S218. And I really appreciate the work of Legislative Council as well as the representative in, I think, putting forward something that is very discreet and elegant in terms of a change to the bill that you passed out, but completely answers VLCT's primary concern. So our feeling, and we testified on the House version of the chloride reduction bill last year, and on this one, including in this committee, but in others and in transportation in both chambers, and our persistent concern with the program that is conceived is that the liability protections are inadequate for municipal applicators. And that has a lot to do with how municipal town highway programs run and are facilitated and are staffed, which is through a network of municipal appointees and employees, and through the work of contracted commercial applicators, and through public sector employees in departments of public works. And when we assess the language, and when I say we, I should be specific, I mean our risk management attorneys who are employed by PASIF, which is the property and casualty insurer for all but currently 2 municipalities in the state of Vermont. So these are the professional risk management attorneys who advise municipal legislative bodies and public works departments on questions of law all the time, every day. That's their job. And when they assess the affirmative defense language that's carried in 218, we think that it would be very difficult for a municipality to meet the standard to receive the full liability protection. And I'll give you a hypothetical but very likely scenario, which is that a town clerk or justice of the peace or someone who's opening town hall that day observes that the wheelchair ramp is slick or it's raining and we're expecting a freeze that night, and they apply salt. And then they don't record the salt treatment, and they don't record the weather conditions at the time of the salt treatment. And maybe they, as a town clerk, have not attended the V-Trans training that's associated with the program. If there is an accident on that ramp, it would be very difficult to reach the standard of the affirmative defense. So what I think I'm happy to answer any questions you have specifically about PASIF, about the program, about how municipal salt application is working. We totally support the broader intent of the bill. We agree we have the same shared goals. All of our municipalities do, which is to protect water quality, to reduce salt application, to save money in town highway budgets, and to help Vermonters with maybe what could be excessive damage to their car from excessive salt application. We support those goals. We think in order to support municipalities using this program, they manage more than 4,000 miles of public road in Vermont in 251 municipalities. We would really need the Booten Amendment to be attached. And I guess the last thing I'll say, and happy to answer questions, is remember how discrete of a change this is. So this is if 218 passes after V-Trans creates the program, if a municipality chooses to enroll and attend the trainings and is qualified to reduce their application under the salt application under the program, and then an accident happens, which results in a claim against the municipality, and for some reason the affirmative defense cannot be used in defense of the municipality, then this would take effect. And all the Booten Amendment does is, in that very specific scenario with that very specific set of events, create parity with the protection on the municipality that the state has long enjoyed since 1961.
So can you just help us, what happens today when that same example you gave us happens? When that salt applicator puts salt on the ramp and there's an accident, what happens? And they're liable.
Yeah, so it depends on the fact pattern and the circumstances, and most of the time that's the first thing that the attorneys for the claimant and the attorneys for the municipality and their insurer. So if they're found liable, then the municipality all the municipalities are insured, some self-insure, Burlington currently self-insures, and some have more than one form of property and casualty insurance. So either the claim could be settled or the court could award, make an award to the claimant. And if the insurance, I'll use the example of settlement maybe, which I think happens more often and sort of is more dynamic of an example. Let's say the insurer says, we want to settle this, we don't want to go to court, we're going to offer the claimant $50,000. And then either the claimant doesn't accept that or the municipality wishes to use their authority to offer above the $50,000, but the insurance company is saying it's going to be 50. We're calling this 50. Then let's say it becomes 100,000. Then the municipality has a few options. One is to use a different line of insurance coverage if they have that available that already exists. One is to use revenues currently available to them within their voter authorized budget. Another option is to seek authorization using their municipal system to find the extra $50,000 for the purpose of the settlement award. And then another is to purchase reinsurance. And so that's really important. And we worked this out yesterday. It was one of the questions I think you discussed in committee, which is that because the state self-insures and has certain requirements on the way it covers itself for liability, there was a question if municipalities have that same ability. And the answer is they do. They're in a different part of the law. Municipalities are able to purchase reinsurance without forfeiting their municipal immunity for like the municipality corporate. And what that allows them to do is come to passive or to come to their insurance or to go out to the insurance market and to purchase additional coverage that would help them meet the full settlement amount.
And to be clear, it's the insurers who are advising you to get a cap on these settlements.
Well, my understanding, I've worked at VLCT for 2 years, but my understanding is that the state tort law was changed to create a monetary cap for state government in 1961. The caps were adjusted in 2011. At that time, VLCT was involved and engaged and asked, as all other New England states do, for the tort liability cap to be the same for municipalities as for state government. I think this is important. It's totally relevant and germane to the chloride reduction program because the state has had a chloride reduction program for some time. In part, I would argue, because they don't have this outside liability that municipalities cover. New Hampshire, that has created the program that you've looked at and that I think is inspiring this bill, also has the same cash liability cap in New Hampshire tort law for municipalities and for state government. And though municipalities are treated differently in the New Hampshire program, they're able to really participate responsibly because of that coverage. So I think for us, we share the goals of the bill. We want reduced chloride application. We want a responsible way for our municipal members to learn how to do that and to put it into practice. We really need this safety net.
Aren't the municipalities already participating in the state salt reduction program without any of this confusion?
Aren't they
participating in the state's trainings for salt reduction in some instances
They're
already?
participating in the local roads program, which has a component, but doesn't have the full component of the BMPs, record keeping and the affirmative defense. So,
yeah.
And one municipality has its own, South Burlington.
And I want to give the representative from South Burlington a chance to tell the committee what your vote was. Did you tell us that?
7-3. Unfavorable.
Unfavorable. Thank you. Did you have some questions over here? You have a question?
I think you said the only thing it did was provide the affirmative defense for folks to go through the program. And I just want to clarify that it also gives this liability cap to municipalities whose staff do not go through the program.
Okay, I didn't interpret the bill that way, so.
Not the bill,
No, the
the
amendment.
amendment.
Oh,
You said something incorrect about the amendment. I heard
Oh.
you say that the amendment only did this very narrow thing, which is for folks who aren't able to take, folks who do the program and follow the BMPs, or whether or not they follow the BMPs, they're certified through the program.
yeah.
That, for them, this liability cap would sort of be below, that affirmative defense. And that's not accurate. The amendment also applies to all municipalities regardless of whether they go to the program that provides this.
I think, thank you for organizing that differently, but my response is that closes in one of the important gaps we're looking at. Like, the city of Burlington has 600 municipal employees, and municipal employees are elected and may not be appointed and seated until between April and July. Like, on an annual basis, this is what I mean, like, sort of the unique ways that municipal government functions in order to provide the really basic service of government is not like what a commercial applicator experiences. And so part of the sort of gap in liability coverage that we're seeking and why we support the Booten Amendment is because that would be true in a municipality that's working to reduce its chloride production, and some, but maybe not all, of the municipal employees who do the work would have benefited yet from the program.
Still feel like you're confused about the amendment because the amendment applies to people who are not trying to reduce their salt. The amendment provides a cap for all municipal employees related to salt, not irregardless, that's not a word, regardless of whether they are engaging in the certification program or they have no engagement in the program. So it just sounded like we're confused.
I'm not confused, but thank you. And I am not attempting to mislead the committee at all. But to be clear, our our member endorsed position, one of our legislative policy priorities for this biennium is to provide this tort law protection in all cases for all tort claims.
Oh, yes, I understand that.
Yeah, so we do support, yeah, so to the extent that it's broadened is to the extent that VLCT supports it more. But I'm not trying to pull a trick. I didn't mean to confuse.
Thought you stated something.
Yeah.
Yeah, I guess I'm a little confused because all of this liability provisions are really outside of our committee's jurisdiction. And we've heard from the judiciary last year and we took testimony. They also were able to take testimony from people who represent the people who get hurt. And like, I have to say, there's a little bit of a parallel here to me to only hear from the municipalities and not hear from the people who are injured, to sort of the issues we were dealing with around Act 181. So I guess I think we really need to be careful that we're not trying to make a huge choice right now that's really not related to our committee's area of jurisdiction and where we haven't heard multiple sides of the issue. So I just wanted to state, I want us to take up the bill as soon as possible next biennium to support VLCT and municipalities in looking at this issue because it raises a lot of areas of curiosity and things that I care about. And I do want to support the overall. And I have registered my support with the chair of judicial.
Thank you.
Other thoughts?
Just real quick, I would just say that, a lot of times when we have these sort of last minute amendments, they're successful when they're really narrow and when they get to a very specific problem that's in the bill that's before us. But this seems like a much more substantive policy change, even though it's a narrow part of that policy, the policy itself about whether municipalities should have the same sort of protection as the state for these sorts of caps on liability damages does actually seem like a big policy change. And this doesn't seem like the right time to be making that choice.
For the right vehicle. Did you have any clarifying thoughts on this before we close up?
No, I don't. I would probably. No, I don't.
All right, do members have any further questions for any of the folks in the room related to this? Okay, is there a motion to find the amendment unfavorable?
I'll move to find the amendment unfavorable.
Sounds like Groundhog Day.
Yeah.
Okay, for straw poll. Raise your hand if you find the amendment unfavorable. Okay, looks like the same vote as yesterday, 10-1-0. Thank you for coming in.